This is the Thursday, February 11th, 2010 meeting of the Zoning Board of Examiners and Appeals. Would you call the roll, please?
Joanna Croft. Here. Holly Sozo. Timothy Bigg. Dean Cars.
Here.
Kenneth Burkhart.
Here.
Jeff Ron.
Here.
Joshua Fink.
Here.
Ann Denny. Here.
Well, welcome, Ms. Denny, to your meeting tonight. Next on the agenda are the minutes from the November 12th, 2009 Zoning Board meeting. Has everyone had a chance to review those minutes? Are there any comments on those? Any opposition to approval of those minutes? Or do we need a motion? Okay. Seeing no objection, we will approve those minutes. Special order of business disclosures. We have 2 cases before us tonight. Are there any disclosures by any of the board? Seeing none, that moves us on to our consent agenda. We have 3 resolutions for approval. Resolution number 2009-031, resolution number 2009-033, and resolution number 2010-001. Does anyone have any comments on any of those? Yes, Mr. Fink.
Mr. Chairman, I was not a member of the board then. Can I vote on that?
Mary, just correct me if I'm wrong. I know that they can vote on minutes. Can they vote on resolutions as well?
Through the chair, he really should vote to abstain on this. It only takes a simple majority to approve the minutes and the resolutions.
Okay, because we'll have 2 board members that would therefore be abstaining.
That's fine.
Okay. And Mr. Fink, which cases were you absent from? Were you in attendance at the
first one? I was not here. These are.
Let's see.
The first 2 I was not here.
November 12th, and then January 14th last month.
I was here January 14th.
So perhaps we would vote on A and B, and then you could vote.
4 is a current majority.
It's just a simple majority of the members in attendance.
That's correct.
So with 6 of us, yes, 4.
I'm sorry, it would be okay to vote on the consent agenda, and then it's fine for me to make notes, and I adjust it afterwards on who abstains, so you don't have to be that picky as to pull each one.
Okay.
Okay?
All right. So the record would show that Mr. Fink would be voting on resolution number 2010-001, and Ms. Denny would not be voting on any of the resolutions on the consent agenda. Thank you, Mr. Fink. Is there any objection to approval of the consent agenda items? Seeing none, consent agenda is approved. We have a postponement tonight for case 2010-003. If anyone is here tonight regarding 2010-003, which was for Lot 5, Block 6 of Sunset Manor, Subdivision Number 2, that case has been postponed to March 25th, 2010. Moving on along our agenda, we have no appearance requests, which moves us to unfinished business / public hearings. We heard Case 2009-162, the public hearing was held last month. That public hearing was closed, and subject to some alternatives being brought before the board, before planning for possible forward on to the board for action. Before I continue, Ms. Denny, you were not at the last month's meeting. However, it's my understanding if you listened to the case, the audio tape of the case, you would be able to act on that, on the case. Have you had a chance to listen to the tape?
Yes, I have.
You have? Okay. With that in mind, we have a 6-member, all members of the board in attendance can vote on that, so we do not have a short board. Therefore, I don't believe we either A, have the requirement, or B, the option of postponing to the following month. Is that correct, Mr. Baird and Ms. Latour?
That's correct, Mr. Chairman.
Thank you. With that in mind, if we could have a presentation of the additional information regarding this case by the board, by the staff to the board, please.
Thank you, Mr. Chairman. The issue of visibility from the neighboring driveway, which is Lot 19, seemed to be, excuse me, is that yes, Lot 19, seemed to be a fair amount of concern for the board. So what we investigated over the past month was using both the code standards and AASHTO standards, what would it take to move the fence out of the clear vision area. The drawing, which is labeled page D, Delta, it's the last of the new information. There's a slightly heavier line on the front of the lot next to Greenland Drive. That's the setback for the clear vision area. If the fence at that southwest corner of the property were moved back 7 feet 10 inches, by the code, the fence would no longer be in the clear vision area. Similarly, the drawing on page C, Charlie, shows the fence moved back 8 feet. That clears the same 7 foot 10 inch clear vision area, but we thought for the sake of another 2 inches, move the fence back the entire 8 feet, which would also have the fence then clearing an AWWU easement and would get the owner out of having to get a letter of no objection from AWWU. Either option would work for the clear vision area. Therefore, the applicant, Mrs. Wegener, is unable to be here tonight. She said her preference would be for the 7 foot 10 inch setback, which is option number 2, because that would allow her slightly more play area. You can see that when in comparing the two drawings. If the entire fence is moved back 8 feet, she loses a little bit more front yard. I told her I would pass that on to the commission, onto the board, but just as a reminder, this is not a clear vision area issue. This is simply an over-the-height fence in the front yard setback. We merely looked at the clear vision area as a possible option because that did seem to be a cause of concern from the neighbor. So that's all I have, Mr. Chairman. I should add, though, that your first question, does the board have the option of hearing this or postponing this? The public hearing's closed, but I believe the code allows the board at any time for findings that it makes that it may postpone a case to the next meeting, so that option still is open to you. Thank you.
Thank you, Mr. Baer. Are there any questions of staff? Mr. Burkhart?
I guess in my mind that the request for the variance is formulated by the petitioner, so has she then officially revised her variance request to match what we see as option number 2 then? And can she do that, I guess, not being represented here directly today?
Mr. Chairman, Mr. Burkhart, I did speak with her. I do not have it in writing. Her preference is option number 2, but she can live with either one if that's what it takes to convince the board that she should be allowed to have the fence in the front yard. The public hearing's closed, so I don't know that we would have had to reopen it to get her opinion on the record or to get her preference on the record. So legally, I think we're all right. She expressed it to me, her option, and I'm passing it on to you.
Okay, but I don't think that we have the latitude to consider multiple options. That a variance request has to be made, and I don't think, I'm unaware of there being any precedent saying we don't think we can approve option 2, so we're going to substitute option 1 in its place, since each of the board members thinks independently. So I think what has to be brought to before us is a concrete proposal that we then vote up or down, right?
That's correct, Mr. Chairman, Mr. Burkhart. We are taking a little latitude anyway, since this is not a clear vision question. But Mrs. Wegener was quite firm. Option 2 is her preference.
Excuse me, Mr. Burkhart, the way I interpret the original request had a site plan which showed the fence encroaching 100% into the 20-foot setback. It's my understanding now what has been revised and is before us is the motion would be to, whether it was approved or not, would be to allow a setback subject to the this drawing shown on option 2. And we would therefore act on that. We've got from staff the understanding that this is the petitioner's request, so that's how I believe we should formulate the motion and act on that motion.
Mr. Chairman?
Yes, Mr. Barrett.
The board is allowed to set conditions of approval for a variance. So if you view options 1 and 2 as alternate conditions, I don't see a legal bind, if you want to view it that way.
Well, we can't approve both. It would be one or the other.
They're just two different conditions, and you would pick one and say, this is the condition that we think helps meet the standards, and that's what she gets.
Mr. Burkhart, did that answer your questions? Or
I think it does. I guess I might be more comfortable if the petitioner was here, but I agree that if with what Mr. Barrett indicated there, that the petitioner has indicated to him their preference, and we can act on that. And I think I would also agree with Mr. Barrett that if whoever makes the motion wanted to consider, the approval of option 2, that it would be within their rights to formulate their motion in that regard.
And Mr. Burkhart, I would agree. I'd be more comfortable if the petitioner was here as well. However, they understood at the last meeting this was going to be postponed to this meeting, and it does not sound like they've asked for to be postponed any further at their request. So I know we always want to, we do our best to make sure the petition's concerns are heard, even if that means extending for meeting or meetings. And I believe that that's been done in this case. Mr. Ron.
Thank you, Mr. Chairman. If I recollect properly, part of our reason for postponement of voting on this issue was in large part due to the neighbor's concern. Mr. Barrett, you state that both the applicant and the neighbor have been shown both options. We heard that the petitioner has a preferred option. Did the neighbor speak to either option?
No, sir, he did not. He acknowledged receipt of it by email, the drawings and the updated staff report, and had no further comment.
Thank you.
And Mr. Barrett, just to confirm for the record what you had written, it's staff still recommends denial for the variance for the same finding that the same standards were not met in the original staff packet?
That's correct, Mr. Chairman.
Thank you. Ms. Croft.
Mr. Barrett, sorry about my voice. As I recall, code enforcement recommended against the original variance request. Has there been any updated response based on this?
Mr. Chairman, Ms. Croft, they did not formally withdraw it, but when I went out to measure the vision triangle, I did take that particular code enforcement officer with me to help, and I shouldn't characterize her behavior or put words in her mouth, but she did seem pleased with the effort to get out of the clear vision area because her concern was a safety one primarily.
Thank you.
Are there any other questions of staff?
I had a question.
Yes, Mr. Fink.
Mr. Barrett, there was testimony at the last hearing that there were other fences in excess of 4 feet, and there was testimony that they had been approved. But in the memo from staff, it indicates that only one other fence higher than 4 feet was observed in the immediate neighborhood. It was a chain link fence, and it did not have a variance granted. And that it references another fence height variance that was denied by the board. Were you able to look into either of those?
Mr. Chair, Mr. Fink, thank you, yes, for bringing that up. It's a little difficult to get to the existing grade to measure the exact height of a fence because of the amount of snow on the ground. But on the same street, we identified 4 others. One has a variance which was denied, so it's illegal. And the other 3 fences, if our rough measurements through the snowbanks are correct, those 3 are also in violation. So the code enforcement officer who was out with me for the vision triangle measurement wrote them letters of notice, what they send out initially saying, we think there might be a violation, here's your chance to respond. So we did identify 4 total, 1 with a variance denied, sent all 4 of them letters.
We may well see a few more variance requests from this neighborhood.
Are there any other questions of staff? Seeing none, the matter rests with the board. Could I have a positive motion for case 2009-162, please? Mr. Ron, thank you.
Thank you, Mr. Chair. Actually, I'll ask for some assistance in fellow board members in working through the motion that I'd like to put on the table. My intent is to, as Mr. Barrett addressed, formulate the motion in the sense that we are voting upon conditions, and that condition being stated in staff's memo dated February 11th. In the case of 2009-162, I move to grant a variance in the R2M district from AMC 21.45.110 to allow a fence taller than allowed by code to encroach the front yard setback. Title 21 limits a fence to 4 feet in height when the fence is within the front yard setback. Move to grant that variance according to conditions set forth in additional staff information, consideration of both options. In fact, is that reasonable? Can we address both options, or do we have to select one in this motion and vote yea or nay?
Well, that's how do we want to handle that?
Go ahead. Sorry.
My thoughts are typically we have a recommendation subject to conditions, and we have those conditions. One of those typically references a drawing of some sort. And I don't know if we would just amend that one condition to reference which drawing we want to discuss, and then maybe during the discussion we can decide if the other drawing should be referenced instead.
Okay. What I'm getting at here, and to speak plainly, is my preference is towards option 1, which is not the petitioner's preferred option.
Well, I think that's why you get, as being the person that makes the motion, you can sure bring that up. Just one sec.
You might want to do the motion subject to the condition.
Yeah.
And then any amendment modifying just one or the other, and then you
Sure.
can present it.
Sure. Yeah, Mr. Ron, we have, and I'm not sure, with a new staff packet, is this page 9, I believe? There, the 3 conditions that were on the original variance request, perhaps make it subject to those conditions, and then we can amend the one referencing the option upon discussion of the standards.
And that way you won't lose the motion.
Is that?
It does. It will require further amendment, perhaps, if, in fact, option 1 moves forward, then one of the department recommendations falls away. I'll go ahead and make the motion as you suggested, and then we'll work it out from there.
Okay.
Would you like me to start over? No? Okay. Subject to department recommendations on page 9 of the staff packet, numbers 1 through 3. And the conditions of option 1 and 2 are referenced on page C and D. No? Did I still miss it?
You can do whatever you'd like, Mr. Ron. So that's your...
According to condition stated as option 1 and reflected on page C of the staff packet.
Thank you, Mr. Ron. Mr. Burkhart, you've seconded that motion?
Yes.
Thank you, Mr. Burkhart. Mr. Ron, you care to speak to your motion?
I would, and again, I'll appreciate board comments regarding the standards themselves. And looking at standard 1, in which staff says it's not substantially met, the board has in the past looked at lot configuration as a consideration in some certain circumstances, and the positioning of the house on the lot and the usefulness of that existing yard creates some warranting of consideration. And in that sense, I would think that standard 1 may be at least partially met. Agree with staff in standard number 2, and that it is as well partially met. Regarding standard 3 and the fact that the hardship is or is not self-imposed, yes, in many senses the fence has been constructed. However, the petitioner has been agreeable to pursue options that minimize, mitigate, and reduce some of the effect of the self-imposed hardship. In that sense, we're in a situation where perhaps we can look behind or beyond some of are typically considered issues and find support for the standard. If in fact that's not the case, then I suggest that in aggregate all the standards may be at least partially met or substantially met in the sense that we can approve the standard or approve the variance in that fashion. I agree with staff in their findings for standards 4, 5, and 6, and that those standards are partially or fully met, and 7 as well. I have tailored the motion, thanks to your help, to address option number 1, in that considering the status of the neighborhood and additional staff findings regarding some fences that are within the setbacks, there is a modified sense of parity that may exist within the neighborhood, and think that the option of the 8-foot setback not only reduces potential conflict with the easement, but also provides a standard look to the neighborhood when facing the house from any angle. Furthermore, the petitioner argued in sense that this fence provided some sense of protection, and I find that perhaps an 8-foot buffer zone may add to that protecting effect. For those reasons, I intend to grant the variance as stated in my motion.
Thank you, Mr. Ron. Mr. Burkhart.
I guess I'd like to thank Mr. Ron for choosing the option that he did. I think since it is a lesser variance request than the original variance request or the other option, I think that maybe helps our decision, or at least the lesser degree of the variance, I think, is an important consideration in our decision. I guess I'd like to hear from additional board members. Initially, I think I agree with staff in terms of their interpretation that not all the standards are met, but I would like to hear more thoughts from fellow board members. I think one of the interesting pieces of information we've heard tonight is the number of similar fence installations on this street that I think we want to be careful, even though we review and the facts of each variance request separately on its own merits. With such a large number of encroachments of taller fences in the front yard setback, I think we should be mindful of setting precedents here. I think this variance request is better than the angled option in that it gives the more regular rectilinear look of that suits the lots in this neighborhood. But I guess I am cautious in terms of the evidence in this case. In most of the standards relates to the individual living situation of these people, and in general terms, if you look at the 7 standards here, they're really blind to the personal situation of the property owners, and they have to do with the land, its configuration, whether the lots are regularly shaped, sloped, whether or not a property is atypical in terms of size, whether it borders an adjacent zoning that's across the street that might be a different use. And I guess I'm cautious in this case that most of the testimony that we heard relates to the individual people and the situation in this house. And I guess I'll open up to other board members for comment. Thanks.
Thank you, Mr. Burkhart. Ms. Croft.
I guess I wanted to speak to Standard 1 first. I think that while this property may not be unique in its neighborhood, I think that the particular configuration of this lot is an unusual circumstance. The fact that the rear yard butting up against the alley has the driveways and it completely covers the back of the property because it is a duplex, that it does not afford this property the ability to use a backyard in the way that we might normally think about that in terms of having an enclosed play area with a fence all the way at the back property line. And so in that sense, we're sort of turned around a little bit here, and so the front yard is a backyard, and so I think that the need for additional enclosed area is one that you would like to see. I'd like to see properties being able to enjoy that, of having enclosed areas. The other unusual circumstance is that the alley is backed onto the PLI, neighborhood, zoning district, and that butting up to Minnesota is an unusual circumstance in terms of the people and the kind of traffic that you get back there, so that the rear yard, the backyard, is really not a suitable place, not as friendly a place for that kind of enclosed activity. So in that sense, I do find, and also this rear yard with the driveway off the back is not, I believe, is not the circumstance in all the houses on that block. The neighborhood immediately, the neighbor adjacent to them has a front yard driveway, and that's why we have the vision issue. So I think that this is, again, maybe not unique, but is certainly unusual in that neighborhood. So I do see that the standard 1 might at least be partially met. Standard 3, I'm still not clear on. Thank you.
Thank you, Ms. Croft. Are there any other comments from the board? Anyone else at all?
Mr. Chairman,
Mr. Fink, thank you.
just briefly, I would concur with Ms. Croft's comments with regard to standard 1. Extraordinary physical circumstances of the subject property. I keep reading that phrase, and I do find the backyard is used as a driveway, and particularly what's behind the backyard. I mean, it's a park that's got a lot of issues, physical circumstances to that park that I think have a significant impact, that are exceptional and extraordinary with regard to the property we're talking about. So I think standard 1 is substantially met. Still working on standard 3.
Yeah, I appreciate that. And I guess I'll weigh in and, well, go ahead, Ms. Croft.
Sorry, just on standard 3, that might be a place where we consider consider a little bit the circumstances there about it not being self-imposed. I mean, the need is sort of the need for it is unusual for the area, and I don't know if that can somehow play into standard 3 or not.
Yes. Thank you, Ms. Croft. I guess I'll offer my thoughts, and I think they probably echo the majority of the board. This has been a tough case for us. We heard it during the public testimony. I think it all the use that the owners have of this lot is something that's very admirable, and I think we all want to do with what we can to help them out. That being said, I agree with Mr. Burkhart. What we cannot look at the personal situation. It's having to do with the 7 standards, and those 7 standards go with the land and with the property itself, not the use of the property. I originally did not intend to support the motion finding that standards 1, 3, and 7 are not met. Ms. Croft, you've convinced me, I believe, that standard 1 is met. And I still have a hard time with standard 3 and even standard 7, that being, is this the minimum? believe that, yes, we may be seeing additional variances coming before us for other fences that are along the street, but, and understanding that each case stands on its own merit, the fact that we have not granted any variances for any of those 4 fences shows me that with the one case that came before us didn't grant a variance. I guess where I am with that is I don't put any weight on the fact that there may be 4 fences that are within a setback that we have not allowed that on any of those cases. So I guess right now, without finding that standard 3 and 7 are met, as tough of a decision as it is for me, I will not be supporting the motion. I can sure be convinced otherwise, but I haven't been able to either convince myself, be convinced by the applicant, or by the board. Yes, Mr. Burkhart.
I guess in relation to standard number 3, we heard the testimony that the petitioner did contact someone from the state, and it sounds like the construction of the fence was paid for, at least partially, by the state of Alaska, and I'm guessing the Department of, Health and Social Services. And erroneously, I think she relied upon them as being the authority having jurisdiction to approve this. And so if you look at standard number 3 in that respect, if she thought she was doing the legal thing, you could consider that in that reference that might not be self-imposed. And in regards to standard 7, if you look at that in terms of a reasonable use of the land, we heard testimony that given the age and the level of activity of the kids, that a 4-foot fence wouldn't be sufficient to be able to keep them within the yard. So I guess I'm still puzzling over this myself, but I do see there being some mitigating factors and still being true to the 7 standards that might mitigate standard number 3 and standard number 7 there. So I'm still on the fence.
Well, Mr. Burkhart, I must say, between you and Ms. Croft, you've done a very good job from my perspective, with standard 1 and standard 3. Thank you. Mr. Ron.
Mr. Chair, if what I'm hearing from the board is some agreement in that standard 1 may be met or substantially met, and what I'm gathering is that decision is based on the fact that there may be some physical circumstance of the property based on its location, proximity to the park, and so on and so forth. In that sense, I'd like us perhaps to take another look at standard 3 in the light of there being, in fact, a physical circumstance of the land to which this hardship is tied. I don't know if that helps those board members who are still having difficulty with standard 3, but perhaps just a little bit more discussion to that point may be beneficial.
By all means, feel free to discuss.
Ms. Croft, you did so well with convincing us of standard 1.
Okay.
Question of paragraph that's often stated by staff in our staff packets, and that's starting with courts across the country have agreed this self-imposed hardship by the owner, which is unrelated to the physical characteristics of the land, is not contemplated by the variance ordinance and accordingly is not sufficient grounds for granting the variance. Well, if in fact what we have is a variance request that is related to the physical characteristics based on some discussion that has preceded us regarding standard 1, then how should we look at standard 3? That may change the description in Part A in that there is a physical peculiarity of the lot and the need for the variance is desired because of that physical peculiarity. That may overweigh Section B in addressing the issue of self-imposed versus non-self-imposed.
Thank you, Mr. Ron. Mr. Fink?
Yeah, I'm not having such difficulty with standard 3 after hearing Mr. Ron.
Could you speak into the microphone a little more?
Sorry.
Thank you.
I'm feeling better about standard 3. You know, I hadn't thought about the state's complicity in this, and to a sense, there's a collateral estoppel argument. I mean, they thought they had authority from the state. It was false, but they were under the impression the state approved this, and there may have been something necessary in providing a play area for them to provide the services, the foster services they were providing. So there's 3 parts to that standard 3. There's the first part, it's not self-imposed. In a sense, I think the state's complicit and possibly stops us from finding it self-imposed. The state was involved in this. Special conditions and circumstances does not result from the actions of the applicant. The same argument. The state was involved in this, was heavily involved with the family and setting this up. The third part of that, it's the circumstances, the conditions, circumstances does not merely constitute an inconvenience. I think this constitutes much more than an inconvenience. It's the lives of these children and the ability to have, you know, the best life they can given the situation they're in. So I'm comfortable with standard 3 having been met. And courts across the country, I'd want to know what courts, I'd want to see those opinions. I mean, that's just a broad summary statement about what courts have ruled. That doesn't have the impact on me that a court case that was cited with some specific language would. So I'm not going to give that a lot of weight. I think standard 3 is substantially met. It was not totally self-imposed. The state was complicit in this and very involved with them and assisting them with this. With regard to standard 7, I believe that's substantially met. You know, we've talked about the peculiarity of the subject property with the location of the house, the driveway in the back, the property across the alleyway. Given that, you know, the variance granted is the minimum variance that will make possible a reasonable use of the land. Having those kids in the situation they're in, that the variance they're asking for with the condition that it be moved back 8 feet, and I support the option 1. I'm glad that's where Mr. Ruin's gone with that. I think really is the minimum variance, making reasonable use of that land. I don't think you would have a reasonable use of the land given the house's location if you required them to further reduce either the height of the fence or move it further back. So I think standard 7 is substantially met.
Thank you, Mr. Fink. Is there any other comments from the board? Mr. Burkhart.
I guess one other item in terms of standard number 7 is that we are looking at a 60% encroachment here versus the 100% encroachment that was originally being requested, and I think that's a significant difference. So in view of all the testimony here, I think this is a very difficult case, but I think I might be inclined to vote to grant the variance.
Thank you, Mr. Burkhart. Are there any other comments on the board? My final comment is I do intend to change my vote, and I will be supporting the motion. I think this board has done a very good, thorough job of evaluating all the standards as well as staff's work on the presentation. So with that, please vote. That motion passes by a vote of 6-0. I should let anyone know anyone aggrieved by this decision has 30 days to appeal. The appeal period starts at the time of the written motion.
Mailing of the written decision.
Mailing of the written decision. Thank you. I don't have my notes today, so I'm trying to go off recollection. Thank you, Mr. Burkhart. Moving on our agenda, that brings us to our public hearing, our first case. Before we get to our first case, I would like to read the order of business for variance requests. The chair shall introduce the case and explain the procedure to be followed. The variance case number and the name of the applicant shall be read into the record. The board shall hear and rule on any objections to the sufficiency of notice. The staff shall then provide a brief Brief outline of the case. Staff presentations shall not exceed 10 minutes. The board may ask questions of the staff. The applicant shall then give his or her presentation. Their presentation shall last no more than 10 minutes. Throughout the proceeding, the burden of proof rests upon the applicant, who must convince the board by a preponderance of the evidence that the variance should be granted. The board members and staff may direct questions to the applicant through the chair. The staff shall then have the opportunity to offer a rebuttal. Rebuttal period shall last no more than 3 minutes. The board members and the applicant may then direct questions to the staff. The applicant shall have an identical opportunity to present rebuttal testimony and to respond to questions. The chair opens the hearing for public testimony. Each person may testify for no more than 3 minutes and may be questioned by the staff. The chair closes the public hearing. The staff, followed by the applicant, shall have the right of rebuttal with neither presentation to exceed 3 minutes. And then the chair shall ask for a positive motion from the board, and the board shall act on the motion. That brings us to our first and only case this evening, case 2010-020, is the petitioner Marge Runzer, or the trustee here. She's indicated they are here. Could we have the sufficiency of notice by the staff, please?
Mr. Chairman, there were 115 public hearing notices mailed out. 6 were returned as not deliverable. One public hearing notice was returned, found on page 23. They were objecting to what they thought was a request for a commercial garage, which is not what we have before us this evening. So I would say that is not responsive to the variance being requested. The request is for 100% variance from the the side yard setback in the R1, which is 5 feet. The property is Lot 10B, Block 6, Poga subdivision, and the property is zoned R1. Briefly, the standards 1, 2, 3 are not met in the department's judgment. And I would note that standard 4 is partially met, 5 is met, and 6 is met. I would make a correction that there was an error in the packet that said it was not met. And 7 is not met. What we have is best shown on page 4, which is the plat. In what are the dates here? The original plat shows that there was a house on the property in 1950, and that the petitioners had owned lots 10 and 11 in 1967. Lot 10 and lot 11 each had over 19,000 square feet. In 1967, they subdivided and created 3 lots, 2 of which had 13,000 square feet each, and the smaller one was 11,400 square feet. And as you note on the plat, there were 3 houses existing at the time of the plat. The subject property that we're talking about tonight is the middle lot, 10B. If you look at the preceding page on page 3, that is the as-built of the property as it is today. And I've drawn hatch marks to show you where the 5-foot side yard setback is. And as you see, it's 100% encroachment. It also shows that the structure itself crosses the property line by 2.7 feet into Lot 10A. The timeline of how this house was added onto is shown in the property history on pages 5 and 6. The thing that is significant here is that there are several dates that are worth remembering. The property appraisal, the hard files of property appraisal records for this property show that March 31st of 1972 is when they first identified a carport on the south side of the original house. We have no better date than that to establish the existence of the carport. March 24th of 72, the property was zoned R1. So if we assume that, for the sake of argument, that the carport pre-existed that date, then they would have legal grandfather rights, as it were, to the carport. And that would have fallen under Chapter 2155-040, which is the nonconforming structure ordinance. However, what we don't have very accurately is when they converted the carport into a garage by enclosing it. But what we think we know is established by an aerial photograph that is dated September the 22nd, 1981. The last significant date then is August the 21st of 1998, at which time they were issued a building permit to construct a pitched roof. So, according to the way the code is written, if we were to say they had grandfather rights for the carport, they lost them at whatever date it was that the garage was enclosed. The second thing that we don't know is whether the carport always was the same dimension as the garage is today, which is, I believe it's 11 feet by, 32 feet, I believe. It's only 11 feet wide, so we're not. It's not a garage that can hold more than one car unless you do it in tandem. But in any event, the record establishes that nonconforming rights were lost. So what does that mean? Well, 2155-040 says that you cannot alter, enlarge, or change a grandfathered structure because then you lose those rights. So that's sort of the history of how, as best as I can tell, how the structure was developed and how it is brought to us today. The fact that they were issued a building permit in '98 was done without it was just a roof permit. They didn't ask for an as-built, as they were required by code to be supplied to them in order to issue the building permit. So the other part of the code that is in play here is 21-25-020, which says that it is a building permit that is issued in violation is disqualified and is null and void. So in essence, what we have is a number of things. In standard number 1, the petitioner platted the property and then somehow knew under which created the size of the lots. And one of the unintended consequences, I think, is that, they obviously created a smaller lot width, which had the unintended consequence of bringing the lot line closer to the existing house. And, of course, as we know, yard setbacks are measured from the legal boundaries of the lot. Standard 2 is also not met. And they knew that it was not met by the fact that when they sold the adjacent property to the south, there is a warranty deed and a deed of trust, both of which include a statement to the effect that they bought the property knowing that there was an easement on it. And that's found on page 37 and on page 36, both of which say that the legal property is described, and then it adds on, subject to an encroachment easement of garage on Lot 10B, Block 6. So on the one hand, you can say that the people who bought the property knew that the adjoining structure crossed onto their property, and they were having to accept the purchase of that lot with that easement in place. It also should be noted that there are letters in here from those property owners who indicate that they have no objection to the garage being where it is, and in fact say that they like having the peaked roof as opposed to the flat roof, and that's found on pages 33 and 34 of the packet. Standard 3 we also find is not met because a structure placed in a lot is an artificial condition and not a natural one, and is therefore disqualifying as a self-imposed hardship. Having said all that, Standard 7 is, it requires the board to either grant the 100% variance or to deny it. There is no lesser variance to be considered. Now, the board has, on the one hand, acknowledged in the past that garages are a reasonable use on a single family, on a residential property, and we would all acknowledge that. And also we would acknowledge that the practical effect here is that this isn't a structure that can be reduced in size or removed and relocated to a conforming location. However, so the board, depending on how you find the other standards, I think that's what the issue comes down to for the board's consideration. And I'll be happy to answer any questions.
Thank you, Ms. Altura. I have a couple questions. On page 29 of the staff packet, the letter from the municipality, and you had referred to some of these dates. I just want a clarification. It says September 21st, 1981, aerial photo shows the house with the addition to the east side of the house, addition on the south side of the house and fence. And I believed on the timeline that had been given, or you had mentioned it, if it exists prior to 1986, that...
No, I've not discussed 1986.
Okay.
I've only discussed that the garage, the carport itself, the earliest date that we can peg it to is March the 21st, 1972. That would have given it grandfather rights because it existed prior to zoning, the R1 zoning. But when it was enclosed, it altered the structure, thereby losing the grandfather rights. And secondly, it didn't have a building permit to allow it to do that.
Okay, so I guess I had something else in mind. So the 1972 was the effective date of zoning. If this, whatever existed prior to that date, had grandfather rights.
Right.
Okay.
The dates are March the 21st is the earliest we can peg it, a reference to it. March the 31st of that same year is the date the zoning became effective to R1.
Okay. Why does 1986 stick out? I'm going to ask you to read
What you're thinking about is there is a provision in the code that says if you have registered a structure that has a dimensional encroachment into a required yard by January 1 of 86, you could register it as a legal nonconforming structure. But that was not done. And in any case, it would not have allowed them to have replaced the roof if that had been done.
Okay. All right. I guess two other questions, then I'll pass it off. It appears that both the directly affected properties on either side, the lot in question and the one immediately adjacent, there don't appear to be any life safety issues. It looks like we have separation. Would anybody know or care, or why should we care? I think it was a Mr. Marsh question that he used to always ask.
Yeah. Well, the answer to that is I can't confirm the distance, but if you remember the previous discussions we've had about that apply to both rear yards and to side yards, is that the intent of the side yard is that your property has a side yard and your neighbor has a side yard. And together those, and in this case, they're both zoned R1 with a 5-foot side yard setback. So together, what you are maintaining is a minimum 10-foot separation of structures on adjoining lots. I can't confirm to you what that distance is between those two lots. I don't know what that distance is.
Thank you. Ms. Croft?
I want to understand, I think, what the alternative is if the variance is not granted. In the letter that was previously referenced, started on page 29. On page 31 of that, it notes that the violation may be remedied restoring the garage to its original scope and scale or obtaining a variance. And the petitioner repeatedly in the request was talking about going back to the flat roof. Has there been discussion of that it is just the pitched roof that is in violation? Because it seems as if really we're talking about the entire structure being in violation, not just the roof.
It is the entire structure. The garage itself is not a legal non-conforming structure.
Right, so then the whole question about just returning it back to a flat roof is not,
I don't think that's accurate. I think it would be more accurate. But here again, I don't know what the dimension. I have not seen anything that shows what the actual original dimension of the carport was, whether it is the 11 by 32 feet as shown on page 3, or if it was something less than that. I don't know. And there's no record that I can find that shows what that is.
okay, so we are not looking at the difference between the structure and the roof. It is just the garage as a whole.
Yes.
All right, thank you.
Are there any other questions of staff?
If I could, Mr. Chairman.
Yes, Ms. Artur.
I think that one of the things, as I understand, and maybe any attorneys on the board could explain it to me, but when you look at the warranty deed and the deed of trust, where it talks about that there is this encroachment easement, it would be my assumption, and I could be wrong, but if the garage were ever destroyed by, for whatever reason, it could not be rebuilt in the same location, even with the wording the way it is in the, because it doesn't say of a garage, it says of garage.
Are there any attorneys on this board who would care to weigh in to that comment? Well, perhaps we can, excuse me, digest that during the presentation.
I mean, depending on what the opinion of the board is, I would recommend if anyone agreed with my assumption, that could be added as a condition of approval that basically would be a new item 3 that would speak to the variance would only last as long as the garage existed, but not in perpetuity. In other words, if it burns down or it's destroyed, it can't be rebuilt in the same location.
Ms. Autor. Any other questions of staff? Seeing none, if we could have the petitioner come forward, please. If you could state and spell your name for the record.
Yes, Mr. Chairman. My name is Kim Qualley. Last name is spelled Q-U-A-L-E, and I represent the petitioners, Margie Runzer and her siblings.
And the petitioner is here, has indicated that
Ms. Runzer is present, yes.
she's recognized you as her representative. Okay. You have 10 minutes to address the 7 standards that we must find are all met in order to grant a variance.
Thank you, Mr. Chairman. Good evening, Mr. Chairman and members of the board. We are asking the board tonight to grant the petitioner's variance and allow this garage to stay on this property and to encroach into the required yard setback. Ms. Croft asked a question about whether this variance is limited to just the roof or whether it encompasses the whole structure. And I think there's some disagreement about what this variance does encompass. And I think that disagreement is not only between the petitioner and the planning staff who drafted the report, but also within the planning department itself. If you go back to the December 2009 letter that was drafted by Irma Cox, in that letter, it specifically states that to remedy this violation would require the petitioner to either restore the garage to its original scope and scale, which means restore the flat roof on the garage, or seek a variance. And so we would argue that this variance really just encompasses the roof and not the whole structure. But I would like to respond to the whole structure as well in case the board disagrees with that and feels that this variance does encompass the whole structure, not just the roof. But first I'd like to just give a little bit of a background that I think would be really helpful for the board to know, which is that the petitioners in this case really inherited this property from their parents. Their mother passed away in 2009, so just recently, and that is when the petitioner, Ms. Runzer, and her siblings inherited this property. They've never lived in this property. They don't live in it currently. They were not the ones that built the garage, that had the roof replaced. They were not in any way involved in building or re-roofing this garage. So they have inherited this problem, but they have not created it. So I think that's a very important distinction, specifically because it relates to standard number 3, which is the self-imposed situation, and they have not created this situation. They've simply inherited it, and they're trying to resolve it because they are trying to sell this property. The garage does encroach over the whole yard setback, and it goes just onto the neighboring lot to the south of it. The petitioner's father built this garage back in the 1970s, so a very long time ago, before he was diagnosed with cancer and before he passed away from cancer in 1983. We don't know at this point if he knew that there were building permits that were required way back in 1970. I think that we have all seen a lot of instances where way back then people either didn't know or didn't understand the building requirements, the zoning requirements. So I don't know whether their father knew that they needed to get a building permit to build the carport and then enclose that carport into a garage. My understanding, though, is that the footprint has never changed. And that is typical of enclosing carports. You don't typically increase them unless you're going to make a 2-car garage where it's really a 1-car carport to begin with. Usually what you do is you take the initial footing, you leave the posts in place, and you enclose the structure. So it doesn't expand in size, it just is enclosed. And that is my understanding of what occurred here. At the time that the garage was enclosed, a flat roof was built on top of it. Over time, that flat roof started to leak, and so in 1998, the petitioner's mother hired a contractor to re-roof the garage roof. And in doing so, they decided to replace it with a pitched roof because pitched roofs are better than flat roofs. They don't have the drainage issues that flat roofs have, and they're aesthetically, they look nicer. So the mother's contractor obtained a permit from the municipality. The municipality issued a permit to re-roof this garage. I have copies of the permit, which I don't think were included in your packet, so if any of the board members would like a copy of that permit, I've got a few extras that I would be more than happy to provide to the board members.
Ms. Qualley, if you do want to turn those in, we'll have to hold those for 30 days to make them part of the file.
Am I okay to approach Mr. Chairman and to?
Yes. Yes.
Mr. Chairman, it's on page 35.
Okay. You may be getting these right back.
On page 35, I believe, is just the worksheet that the contractor filled out. It's not the complete permit that was issued, so it's only the application that the contractor completed. What I've provided to the board is an actual copy of the permit that was issued by the municipality, which allowed the contractor to go ahead and re-roof the garage. The petitioners, the siblings, sought a determination from the municipality as to its non-conforming status of the garage. They did this in anticipation of selling it and wanted to make sure that everything was okay. They received the letter dated December 3rd, 2009 from the land use plan reviewer, Irma Cox, which is attached to the staff report at page 29. And again, that essentially told the petitioners that they either had to restore the flat roof to the garage or obtain a variance for the pitched roof. And that's why we believe that this variance is really limited and focused to a pitched roof versus a flat roof, and not the structure in its entirety. The variance should be granted for the following reasons. As I stated before, the petitioners inherited this property. They did not create the encroachment. They inherited the encroachment, and they're really just trying to resolve it. They were no way involved in building a garage or having it re-roofed in 1998. They're just really trying to resolve this issue. The neighboring property owners, as you already know, have written a letter in support. That's at pages 33 and 34 of your packet. And they would be the owners that would be most affected by this encroachment, and they are okay with it. The warranty deed that they accepted at the time they purchased the property is not only just an acceptance of this encroachment, they were okay with it, and they indicate that in their letters. Laura Easton is one of the owners of that adjacent property. She is here tonight, and she is willing to testify and answer any questions that the board may have for her as to her support of this garage remaining as it is, the pitched roof remaining as it is, and nothing changing, and that she's fine with the encroachment in the garage staying as it is. There also are no public or departmental objections to the existing garage. Those comments start at page 17 of the planning staff report, with the exception of the one neighbor that thought this was going to be a commercial garage, which we don't consider an objection because he misunderstood what this variance was for. There are no other objections from any other departments. Strict application of the code would create an exception and undue hardship on the petitioners who did not create this encroachment. They only inherited it, and they're just trying to resolve it. Making them tear down a roof and restore it back to an inferior flat roof would be a significant burden to them. It would be costly, and it doesn't really serve any public good. Flat roofs, we all know, are inferior to pitched roofs. They create drainage problems problems. The flat roof that was on this property did create a drainage problem for the Eastons, who are the adjoining property owners. And that is part of why they would like the pitched roof to stay as it is, because they're not having any drainage problems anymore. And if the petitioners have to go back to a flat roof and restore this garage to where it was before, those drainage issues might be recreated. And that's not good for anybody. There are no life safety hazards with this variance. The garage has been there for over 30 years. The pitch roof has been there for over 20 years with no safety concerns, no safety hazards, no safety incidences. It has added value to this property. I believe it's added value to the neighborhood. It's alleviated drainage problems on the adjacent lot. And the front corner of the garage, these properties, you can tell from the plat drawing, the houses on the two properties that are really affected by this variance, the subject property and the adjoining neighbors, their houses are slightly offset. The subject property's house is back a little ways on their property, and the adjoining property owners are a little more forward on their property. So they're kind of kitty corner. And so the front corner of the subject property garage that is closest to the adjoining neighbor's property, the back corner of their house, there's about a 20-foot distance between those structures. So there's well over the 10-foot fire separation that is required, and certainly 20-foot is a significant amount of space and distance between the properties.
Can you please summarize, Ms. Qualley, your 10 minutes or well past?
The garage was built prior to 1986, so under Anchorage Municipal Code 2155-040, it is a legal non-conforming encroachment. That means that it qualifies for certification as a non-conforming encroachment status, and I don't believe the code requires that it had to have been registered as non-conforming prior to 1986. What the code regulation says is that any structures existing structures with dimensional encroachments into required yards that were constructed prior to January 1st, 1986 may continue in existence provided the following requirements are met. An application for the registration of non-conforming encroachment is submitted to the Office of Planning. It doesn't say that registration has to occur prior to 1986. It just says you need to register that property. And it also requires that the encroachment not be a life safety hazard. This property is not a life safety hazard. The garage was built prior to 1986. If I could, Mr. Chairman, just a couple quick more points. The addition of the pitched roof did not change the property's non-conforming status. It neither enlarged it, expanded it, or extended the structure. It simply replaced an old roof, which the municipality approved in 1998 by issuing permit number 98-0985 to the petitioner's letter to do it. The municipality is really stopped at this point from deciding that the new roof constitutes an alteration to the structure which changed its non-conforming status, and so it violates municipal code. If the new roof violates municipal code, then the municipality should not have issued the permit, and they did. And the mother proceeded in good faith with that permit. This variance will make it possible for the petitioners or whomever they sell the property to make reasonable use of this single-family home. This property is in residential. The home is a reasonable use of the land, and the garage is reasonable use given Anchorage's climate. Therefore, we would really ask that the board grant petitioners variance and allow this garage to continue to exist.
Thank you, Ms. Qualley. Are there any questions? Mr. Burkhart.
Yes. Could you tell me what year or when the garage was enclosed? And
the garage was, I don't have a specific year, Mr. Burkhart. I know that the garage was enclosed in the 1970s. The petitioner's father enclosed the garage. He built the carport and then he enclosed the garage. He died in 1983. he's the one that enclosed the garage. He was sick for the 3 years preceding his death, which means that this garage was enclosed in the 1970s.
Okay, after 1972, would you guess? Or can you confirm that with you?
I can't confirm that.
Okay. I guess I'm reading under the non-conforming structures, and there's and what it reads there is that no such non-conforming structure may be enlarged or altered in a way that increases its non-conformity, but any structure or portion thereof may be altered, decrease its non-conformity. And so, I guess, in my mind, I think it is germane in terms of when the garage was, or when the carport was enclosed to a garage, in terms of, in my opinion, that increases the nonconformity, as well as when the roof was constructed.
Mr. Burkhardt, I think the roof was constructed at the time of the carport, which was prior to zoning. The carport was constructed sometime between 1968 and 1972.
With a flat roof?
With a flat roof.
Okay. When was the roof constructed with the pitch?
1998.
Okay. That's all I have.
Thank you, Mr. Burkhardt. Are there any other questions of the petitioner of the board? Does staff have any questions of the petitioner?
No, Mr. Chairman.
Thank you, Ms. Crowley. With that, we'll open the case up for public testimony. Is there anyone from the public wishing to testify? If you're represented by the petitioner, if you're the applicant, you cannot go. That was part of your time. This is for the public. Hello, if you could state and spell your name for the record, please.
My name is Laura Eastham.
Thank you, Ms. Eastham.
Okay, I am a neighbor to the south, and the garage does encroach on my property, but we knew that when we bought it, and it doesn't bother us at all. In fact, we like, it's okay to have it there. It's not bothering us in any way, and we're fine with it. Just like that letter says, it's not bothering us. And if you put a flat roof, then actually the rain or the snow would come off onto our property, causing our property then to be drenched with all the extra excess water. The way the roof is now, it goes off like this. And so when the snow falls off of her roof, it falls into her own driveway. And when the snow melts, then it goes into her own property and doesn't come into our property. So we'd like to keep it the way it is.
Thank you, Ms. Eastham. Is there any questions? Mr. Burkhardt.
Would you have any difficulty with the garage disappearing?
I think it would be uglier. I really would have difficulty with that.
With no garage at all?
Yeah, the garage, it doesn't bother us. And if you take it off in the house next door, because what's inside her house, if you take the garage off, it would be ugly. The side of her house is the garage. You can, if you were to take the garage off, it would be less appealing, less aesthetic, I guess.
Okay. Well, they could put siding over the...
Well, yeah, I guess, but it would be ugly the way it is.
Thank you.
Thank you. Is there anyone else from the public wishing to testify? Thank you, Ms. Eastham. Anyone else at all? Seeing none, the public hearing is closed. Does staff have any rebuttal?
No, I'll answer questions.
Does the applicant have any rebuttal they'd like to offer?
Thank you, Mr. Chairman. I just wanted to emphasize that important date in 1986 that the structure was built prior to 1986, and as such, it qualified as a non-conforming encroachment. That is really important here because it had those rights, and so really what we're looking at is the roof. We're not looking at the structure itself, we're really just looking at the roof. And if we put it back to a flat roof, it just doesn't make sense. I also wanted to ask the board members, I have extra copies of my summary, if that would be helpful for the board members to have a copy of.
Again, you're more than welcome to submit. We will just have to retain one copy for the file. Thank you.
And if there's any other questions that I could maybe answer?
Mr. Burkhardt had one more question.
I guess I understand your position in terms of the non-conforming determination by Ms. Cox and whether the project or the structure could be brought back into conformity by removing the sloped roof and replacing it with a flat roof. I guess, in my opinion, that's really not the purview of the board, that in terms of making that determination, that's something for planning staff to do. Our job here is to either approve or deny a variance. And so, at least in my mind, that issue really isn't germane to the case, that it's our job to either approve or deny the variance, and how it ends up moving from there is really something that is the responsibility of planning staff. And I didn't know if you had any reaction to that, or...
My only comment to that is that as board members, you have to decide, I guess, the scope of this variance and whether it is strictly related to the replacement of the roof or whether it encompasses the whole structure. And we believe that it just relates to the roof. And we were told by planning staff, by more than one planning staff member, that this variance encompasses just the roof. And that to bring this structure back into conformity, you just have to take off the pitched roof and put the flat roof back on. We've been told that by several planning staff members. The other alternative was to come here and seek a variance for the pitched roof. And that's what we believe we're here to do.
Okay, Ms. Qualley, I think maybe there's a couple thoughts that I have. One of them is it possible for them to request and research the non-conforming rights that they're saying? They're saying that this garage has been built prior to 1986. If that's it, Ms. Artur, could you speak to that one?
I would call your attention to the portion of the code, which is 2155-040D, which is where it speaks about pre-existing to January 1 of 86. It doesn't say you automatically have a legal nonconformity if it pre-existed. It says that it could become legal provided the following requirements are met. And one is that you have to make the application to register it as a nonconformity. And that B, the encroachment is determined not to be a life safety hazard by the department.
Ms. Artur, could we take this in steps then? Can they make application to have that determination?
Well, in my view, no. And here's my reasoning. This body and the department does not have authority over the building code, which is Title 23. And getting a building permit for a roof really is more of a structural issue. And we don't care whether the roof is pitched, gabled, or flat. The only thing that this body, this board, has the purview and the authority to look at are dimensional encroachments. And as this came forward, that is, as you see it on the as-built, we're not looking at a roof. Either I mean, the board doesn't have the authority to just grant a building permit.
No, I'm not, I guess the applicant is under a different impression on what's before us tonight. What my question is, it does not appear that they've made application to find out whether non-conforming rights exist or not. However, why can't I guess what I'm thinking might be the best thing to do is we postpone this for a month, not act on this, so they do not lose their ability to apply for non-conforming rights.
Well, I have another suggestion. The board can make that determination. I mean, this body tonight, by granting the variance, you would then be saying that it has legal non-conforming rights. But you have to have, your reasoning has to be pretty sound in order to reach that determination and that finding.
I realize that, and I understand that. However, the applicant does not, they've asked us, what I've heard from the petitioner is just act on the roof itself, whether it's pitched or flat. We do not have the ability as a board to act on that. The petitioner believes we do.
Well, let me ask you this as a practical matter. If you didn't have the encroachment of the structure, then you wouldn't have a roof. You have to have a structure to place a roof upon.
The letter, correct, okay. The letter they received, though, from the municipality said, take the roof off, make it a flat roof, and revert back to non-conforming rights. I'm paraphrasing, but there's an inherent misunderstanding, I believe, in what the petitioner is asking for tonight. So I don't want our actions as a board on this variance, if by chance it were to be denied, they lose their opportunity to request those grandfather rights. So if everyone is on the same page and the petitioner understands that we are looking to grant a variance for the land, for the encroachment, irregardless of whether it's a pitched or flat roof, and you understand that, are willing to go forward with that, that's, I guess, something I'd like to get clarification from the applicant on, because it sounds like there's a misunderstanding here.
If I may.
Yes.
I think I don't believe that there are any more pieces of evidence, as it were, that is going to document the dates of when certain things have happened. I think we've done that. I think the petitioner hasn't argued that there is other evidence out there pertaining to dates. It may be that we might be talking about dimensions in terms of the length of the garage, but I'd be willing to not make that. That's, to me, is not the issue here. I think the board, if they find that it is a legal structure having existed to prior to January of '86, which I do not contest that assumption, by the way. I'm just saying that technically, legally, it's never been registered. They never applied for it, therefore they can't have something that they never applied for. But if the board wishes to go that route and make that determination, then the issue is the board has to go through the exercise then of addressing the 7 standards based on that new finding.
Mr. Fink, and then Ms. Croft.
I'm not sure. It's muddying the water a little bit more for me. I'm not sure what we would then be. Well, let me back up. I'm sympathetic to the petitioner's argument with regard to 12-5040D. It does require an application. It absolutely sets no deadline on that application. They could apply for that now.
Yes, they could. But as of tonight, they have not done that. However, this variance could stand in that as that petition, and the board then could make that finding.
The difference would be, in my mind, if they didn't, if the variance wasn't granted, have they been precluded from applying to save the flat-roofed garage?
May I respond to that, Mr. Fink and Mr. Chairman? I believe that the letter from Irma Cox dated December of 2009 speaks to this issue. I believe what she is saying in her determination letter is that there are non-conforming rights separate from the roof. That if the roof were restored back to a flat roof, this garage is fine, which means it has legal non-conforming rights. That's what she's saying in her letter. So I think a determination has already been made by the municipality that this structure has legal non-conforming rights. The pitched roof, she's saying, violates code. And that if you restore that pitched roof back to a flat roof, you're fine. The structure's fine. Not only is she saying in that letter, but I confirmed that with another planning department staff member on the phone today. So I do believe that letter is already a determination that this structure is a legal non-conforming structure.
Mr. Chairman.
Yes, Ms. Atur.
If we all agree that it existed prior to 1986, which I'm not hearing any disagreement on that point, and that we're concluding that it does fall under paragraph D, which would make it a legal nonconformity, we must also recognize that paragraph D3 goes on to say that once registered, the encroachment shall enjoy all the protections and privileges affording to a non-conforming structure under this provision, which takes you back to 2155-040A1, which basically says you can't alter, change, or enlarge it. Now, having said that, the board can look to 2155-060, which talks about repairs and maintenance. And if the board were to conclude that the roof constituted a health or safety issue, then the replacement of the roof could be considered as being allowed under 2155-060.
Could be considered to be allowed by whom? By us, the board?
This board.
Okay. Mr. Fink.
But I'm just cautioning you that if we're saying that it is a legal non-conforming structure, which I have no objection to, we also have to acknowledge that it then falls under paragraph A1, which says you can't alter, change, or enlarge the nonconformity. So in order to get to an approval, is what I'm saying, is the board has to make a finding under 2155-060.
Thank you, Ms. Atur. And you're piercing the void and speaking to me, I think. I wanted to make sure we were procedurally that there weren't opportunities lost by the applicant. So say the applicant applied for nonconforming rights. They were granted by, yes, you had a flat-roofed garage prior to construction in 1986. Now, to have a roof with a pitched slope, you lose those non-conforming rights.
That's correct.
So therefore, you have to apply for a variance.
That's right.
For the garage to encroach into the 5-foot side yard setback.
Exactly.
So we may be here 2 or 3 months down the road, depending on how that came to pass.
Can I ask a follow-up on that?
Yeah, I'm going to let Ms. Qualley speak for a second, and then Mr. Fink. Did I summarize that correctly, Ms. Atur?
Well, you did, but I also think that there is a basis if the board chooses to, that they could find that for a variance.
Mr. Chairman, just so it's clear, because I think looking at this in a linear way, who determines if the repair of the roof would fall under 2155-060? I mean, is that a board question or a department question?
The question is
let's assume
it's an alteration. It's an alteration. On the other hand, and it does fall under this board's authority.
So let's assume for a moment that it's an existing structure. It's a non-conforming legal structure under 2155-040D.
Yes.
And so now they're subject to A, where they can't add on to it unless it's a repair and maintenance issue under 55060.
Right.
That's a determination this board can make?
Yes.
But wouldn't the applicant first have to establish it as a legal non-conforming structure by registering it with the city?
Yes and no. If it wasn't that they were before us tonight, yes, they would have to go in and do that.
So this board has the authority to...
But the board has the authority to say, yes, the fact that they absolutely failed to make the application, you could say that the variance itself is asking that. I mean, we've established that. The record has established those dates, and I'm not disputing those dates.
So our motion wouldn't be something like going through the standards. Our motion would be to accept it as a non-conforming structure under 2155-040 and then finding the new roof to be a repair under 2155-060.
Right, but then what you would have to do is you have to still make the findings that the 7 standards are substantially met. And I think if I were to be posing those standards findings for the board, I would say that because the board has determined that it does have legal nonconforming rights as having existed prior to January 1 of 1986, that does constitute a extraordinary physical circumstance because the code does recognize that as being permitted. That would make Standard 1 as having been met. Standard 2 would be because the physical circumstances have been met through the declaration that it is a legal nonconforming structure, would you be depriving the applicant of the rights commonly enjoyed? Filling the blank. Number 3, is it self-imposed? Well, now you've already made this finding that it is a legal nonconforming structure, and therefore the standard, that's the 2-part, I believe, where you've already answered the first part, and the second part has to do with the need for the variance. And the roof, if you determine that that is a life safety or a issue related to the structure itself, then you would find that it was not the result of the action of the petitioner. In other words, they're doing it, they're repairing something that would be more than detrimental to the garage portion. In other words, structurally, you have to maintain the integrity of the structure. 4 is doesn't adversely the adjoining property. 5, it's not a use variance. It's dimensional, and we've already established that by prior to 1986 rights. 6 would be found to be met because they're maintaining the integrity and the safety of the building, and it has no adversity to the general public. And that 7 is it would be the minimum variance.
Thank you, Ms. O'Toole. Ms. Qualley.
Thank you, Mr. Chairman. I think that the board is able to make a decision about the legal non-conforming rights, and I think that the board is able to do that not only because you have authority to do that, but also based on the determination that the municipality made back in December of 2009, where they indicated that the only issue with this structure, it's not the structure itself, it's the roof. If the roof was restored back to a flat roof, this property would no longer violate code because it would be a legal non-conforming structure and encroachment. So I think the board can make that determination that this is a legal non-conforming structure based on the determination that's already been made by the municipality back in December. And I agree with Ms. O'Toole. Thank you very much for pointing out that this really was a repair to this roof. The flat roof was a drainage hazard. It was leaking. It needed to be replaced. And it was replaced with a pitch roof that no longer creates any safety issues and no longer creates drainage issues. So I really do believe that the board can make a decision on this tonight without the need for an additional continued hearing, that this pitched roof, that this is a legal non-conforming structure, that it is a legal non-conforming encroachment, and that the pitched roof was a necessary repair. Or, in the alternative, grant a variance for the pitched roof.
Thank you, Ms. Qualley.
Thank you.
With that, the matter rests with the board. Could I?
One more question to staff.
Yes, Mr. Fink.
I guess I understand where you're going, Ms. O'Toole, and thank you, but why would the board need to grant a variance if the alteration of the structure falls under 2155-060? Do we typically get requests to make repairs on legal non-conforming structures?
What I'm saying is that 2155-060 gives the board the authority to say that they can do more than a 10% improvement in order to replace the portion that is unsafe. Otherwise, what they could do is they could do 10% a year legally, but they replaced 100% of it. So, to me, the way to think about that is you don't replace 10% of a roof. You either do it all or you don't do it. And given our understanding of the condition of the roof, they found it to be a necessity to replace it. Therefore, 2155-060 allows the 2155-040A1 allows you to justify the alteration of the structure.
I may have it, I'm not sure, but that's good.
Thank you, Ms. O'Toole. Thank you, Mr. Fink. Could I have a positive motion from the board, please?
Mr. Chair, before you proceed, I would add that if the board chooses to approve this, I would add condition number 3, that the non-conforming structure cannot be enlarged any further, and that once it is destroyed, it cannot be rebuilt within the 5-yard setback.
And you would add that as condition number 3?
Yes.
Thank you. The matter still rests with the board. And I think my monitor's working. Okay, could I have a positive motion, please?
I can try it, but I'm not sure I'm going to get it right, because legally how this is playing out is not so clear to me.
All right, well, Mr. Fink, would you care to make your motion, please?
So it's going to be slightly different than I suppose the request on the packet. Well, I'll move that we grant a 100% variance from AMC 2140-030G, the minimum yard setback requirements, to allow the existing attached garage to encroach 5 feet into the south 5-foot side yard setback based on the board's determination under 2155-040D.
Now, would it be subject to the conditions?
Yes.
I'm sorry, was that where you were going? I apologize. Page 12?
Subject to condition 1, 2, the additional condition that it be not enlarged further, as number 3, and number 4, that it not, that the garage not be allowed to, if it's destroyed, it not be allowed to be rebuilt into the setback.
Thank you, Mr. Fink. Could I have a second to that motion? Oh, wait a second, it's not showing up, but does that hand sign indicate Ms. Croft? Ms. Croft is seconded. Thank you. Thank you, Ms. Croft. Mr. Fink, would you care to speak to your motion?
I will, Your Honor. Excuse me, Mr. Chair.
I like that better.
Being in the court. Do I need to add for findings? I think I need to add findings before we address the 7 standards as to the non-conforming legality of the structure. So as part of that, I believe that we would be finding that it is a legally non-conforming structure under 2155-040D. But under 2155-060, we have the authority to grant a variance to the 10% limit on any repairs necessary for health and safety purposes. So those would be inherent findings necessary, I think, to move forward on this.
Thank you, Mr. Fink.
The difficulty I'm going to have is on the findings that Ms. O'Toole explained so well with regard to the 7 standards. On number 1, I believe that standard is met, given our findings that it's a legal non-conforming structure under 2555-040. Under standard 2, because of the physical circumstances of the non-conforming legal structure, the strict application of the code would cause a hardship in that it had a flat roof that leaked, that put water on the adjoining property. The pitched roof, not allowing the pitched roof would create an exceptional undue hardship. I think standard 2 is substantially met. Number 3, the hardship's not self-imposed as a non-conforming legal structure. They have to deal with the fact it's there, it's a legal structure, the roof needed to be repaired. It was done, in fact, prior to their ownership of the property. So I believe standard 3 is met, substantially met. On standard 4, the variance, if granted, will not adversely affect the use of the adjacent property as permitted under this code. I believe that standard is met, and I would rely largely on the testimony of the adjacent property owner. Standard 5, the standard is met for reasons stated in staff memo. Standard 6, the variance, if granted, does not adversely affect the health, safety, and welfare of the people of the municipality of Anchorage. I believe that standard is met, again, given the fact that it is a legal non-conforming structure. We've had testimony as to the distance between the structure and the adjoining property. There should be sufficient space there for purposes of fire and other safety hazard issues. And standard 7 is met, given that it's a legal non-conforming structure. If my motion's adopted, the variance is the minimum variance to make reasonable use of the structure.
Thank you, Mr. Fink. Ms. Crowell.
I agree with Mr. Fink on addressing all 7 standards. I do believe that in terms of standard number 3, about the hardship being not self-imposed, the fact that a permit was issued to the previous owners in 1998 by the municipality, I also think that that is an issue that they did rely upon that when they altered their non-conforming structure.
Thank you, Ms. Crowell. Mr. Burkhart.
I don't plan on supporting the variance request. I guess I agree with staff in large part that the standards aren't met. In terms of standard number 1, I don't think, I agree with staff that I don't think that is met. I agree with staff, I don't think standard 2 is met. In standard 3, variances run with the land, that they transfer from one property owner to the other, and I think we're free to interpret that with latitude. But in this case, you have the person that created the encroachment is the same person that replatted these properties, and I think that's a significant fact. If the transfer of ownership was enough to extinguish that the hardship would not be self-imposed, whenever there was a variance request, all you'd have to do is sell a property to your brother or sister or something like that, and then, there's no culpability there. I think in this case, because the construction of the carport, then enclosing it, then putting the sloped roof on it was from the same people that replatted the property, I think that weighs on, at least on my mind, in terms of standard number 3. Standard 4, I would agree, is at least partially met. Standard 5, I think is met. Standard 6, I don't think is met. That we've had testimony here that, even if we were in a district that allowed construction right up to the property line, as in some of the commercial districts, that it would require the exterior wall to have a fire rating, and this building doesn't. I guess I'm also troubled by the issuance of the re-roof in looking at both the information in the packet in terms of the application of that and the structural permit that was issued. The structural permit that was issued said re-roof only, and the application indicates that the composition roofing was being replaced with the metal roof. That the slope roof here never underwent a structural review. We don't know if it can withstand 40 pounds per square foot load or not, because nothing was ever submitted for permit, because it appears that it was introduced as a re-roof where you're just taking off the exterior finish of the roof, doing no structural work, and coming back on and putting the same or similar type material. There were significant structural modifications that occurred here in terms of that slope roof. I don't know if those are trusses, if they're 2x4 joists, if they're 2x12 joists. So I think there is an issue here in safety in both in terms of not being a firewall on the property line, plus there being no structural review of that. And as far as standard 7 goes, that the general reason why we had nonconforming uses and that those rights are extinguished over time and they're not supposed to be enlarged and altered is that in this particular case, there's numerous places where a new garage could be constructed, either in the front yard or in the rear yard that would fully meet the setback requirements. And in terms of looking at that as a minimum use of the land, I don't think it's a question whether or not this owner has a right to have a garage. I think the board has found that in the past, but I think there's multiple places on this property where a garage could be constructed. We only look at what's in front of us in terms of going up to the property line. That the building actually crosses the property line isn't an issue for this board here. But having a structure that comes right up to the property line is something that I don't think this board should lightly approve in terms of allowing that to continue into the future. And so for those reasons, I don't intend on voting for the variance request.
Thank you, Mr. Burkhart. Mr. Ron.
Thank you, Mr. Chair. For the record, I intend not to support the variance request as well for two primary reasons. If I were agreeable to the inherent findings that Mr. Fink has put before us, in which we're reviewing the 7 standards, I'm in agreement with Mr. Burkhart's interpretations. I appreciate your technical perspective and assessment of those standards and agree to the fact that they're not substantially met to grant the variance. However, I'm still hung up on those inherent findings in regards to AMC 2155-060 and what constitutes an ordinary repair. And what I think we're looking at here is a redesigned effort that is more than just an ordinary repair that went above and beyond fixing the problems associated with that original roof. Had we been looking at a replaced flat roof that just indeed repaired the problems at hand, then I may be agreeable to assessment of these standards under consideration of that repair maintenance code. Furthermore, the lack of an application for the registration of a non-conforming encroachment is a sticking point to me and requires a leap that I'm not willing to make in addressing this as a legal non-conforming property, or structure.
Thank you, Mr. Ron. Any other board members care to comment? Ms. Denny.
I don't agree with Mr. Burkhart's assessment of the fire separation. I see that there's at least 20 feet of fire separation between the two buildings. The fact that it has a metal roof is also an additional fire block. He did file for a permit. It looks to be a licensed contractor. The permit activity would have had to have been reviewed by the city, so it would have had to have meant code, which would mean structurally. So I do plan to support the amendment.
Thank you, Ms. Denny. I intend to support the motion as well. And I look at it from the standpoint whether it's a carport or a garage, the footprint has not changed. It has not changed substantially. So whether when it was enclosed is not of issue. I appreciate Ms. Artur's clarification, I think, for my benefit on they could very easily apply for, and I think it's a given that they receive non-conforming rights for the structure with a flat roof. They've come before us for the request for a variance to put a pitched roof on this structure. And the question then is, does this warrant granting a variance? Whether each case does have to stand on its own merits, but based on past history of this board, we have looked very favorably on buildings that encroach into setbacks that have come before us for modifications. Whether I don't know how you can, whether it's 10%, 20%, 90% modification, we're basically adding a roof, changing the roof of this structure. The setback, the petitioner's lot line is a line. It could be at an angle, it could be any direction. The petitioners have obtained from the most affected property owner, they have, in the purchase agreement of the adjacent lot, recognized that this garage exists. The current property owners have indicated they have no objection to that property owner or that the configuration of that lot. Again, it's the no harm, no foul. I would argue that anyone driving down the street would have no knowledge that there is any encroachment. So I feel that they've addressed the issue of the setback as far as the requirements. I concur with Mr. Fink. I find all 7 standards are met. All 7 standards are met. I do intend to support the motion. Mr. Burkhart.
I guess I just want to clarify a couple of items that, yes, there is some substantial distance between the two structures, but the owner of the adjacent lot presently and whoever owns that property in the future has a right to build up to within 5 feet of that setback. So, yes, there is separation distance between the buildings right now, but that does nothing to encumber the property owner from building right up to that 5-foot line, and with actually having the house go 2.5 or 2.7 feet over the property line. So the adjacent property owner has a right to build up within 2.3 feet of this house with a non-rated wall. So that's what I indicated in terms of where the International Building Code has fire rating it, that there's the recognition that one property owner never has control over what can happen onto the adjacent property as it's developed into the future. To the comment that the structural permit was issued, I think it's on page 2 or 3 that Scott Hahn was the person who signed off on that, and by his signature are the words re-roof only, which indicates that it was just what he was approving was simply a changing of the finish from a composition roof to a metal roof as it's listed in the application. And so from my experience with the building department, I guess I see that he did nothing there in terms of, and he qualified his approval based on a re-roof only, and he didn't go through the analysis of structure and such. So I appreciate Ms. Denny's comments, but I wanted to get that on the record as well.
Thank you, Mr. Burkhart. Mr. Fink.
Briefly, Mr. Chairman, I concur with your remarks, and with regard to Mr. Ron's comments, just on a legal point, in my motion, we're making a finding that it is a legal non-conforming structure, and you have some difficulty with that because they didn't register it. I personally probably would have preferred a route where they registered it and went through those processes. At staff's suggestion to make government more, I think, efficient and expeditious, they suggested we have the authority to do that. So that's a bit of a shortcut. But I want to just be clear to you, I prefer they had registered it. But on staff's counsel that we had the authority to do it, based on that, I found the 7 standards, just so you understood where I was coming from on that.
Mr. Ron.
Thank you, Board Member Fink, for your clarification. I appreciate the additional information. My previous comments stand.
Are there any other comments from the board? Seeing none, please vote. The motion must pass by a majority of the fully constituted board, which would be 5 votes in favor, There are 4 votes in favor of that motion, so that motion fails. I must announce any party aggrieved by this decision has 30 days upon the mailing of the written notice to appeal this decision. I believe is that the correct statement, Mr. Barrett, Ms. Autor? Thank you. With that, that ends our public hearings. That's the last and only case of the night. Do we have any reports? Or we have, I guess, no reports. My only comment, I believe our elections for chair, vice chair, and parliamentarian will be next month. That's correct? So everyone get your speeches prepared. Does staff have any comments?
Just a reminder, Mr. Chairman, it's the 25th next month, not the 11th.
Thank you. Yes. 25th. And do we have an indication on the load of the caseload?
Mr. Chairman, at this point, 1, 2, 3, 4 cases.
Okay. Thank you, Mr. Barrett.
Mr. Chairman, did all the board members receive the email about stipends late this afternoon?
Yeah.
They're gone as of February 2nd?
Yep.
It's over. The party is
The
done.
gravy train's over. All right.
Boy, that's the only reason that I signed up for this board was the stipend.
With that, the meeting is adjourned, and we didn't make it till 10:30.